Welcome to the Family and Collaborative Law podcast series. This podcast will address prenuptial agreements by Debra Cantor, attorney at law. Ms. Cantor practices in the family and collaborative law and litigation groups at McNees.
Prenuptial agreements are contracts signed by individuals before they are married, which change the way the law is applied to their assets, debt, and income in the event of separation, divorce, and death. When there is no prenuptial agreement, the Pennsylvania Divorce Code sets forth the manner in which the courts will view and distribute property and debt, and also how spousal support and alimony may apply in the event of separation and divorce. Should a spouse die, the Pennsylvania fiduciary statutes govern inheritance rights as well. There are many reasons that individuals should consider a prenuptial agreement. Although some may feel that a prenuptial agreement demonstrates a lack of commitment or love in a relationship, that is not the case. Most people entering a prenuptial agreement are looking for certainty in the event the marriage ends in a manner they had not anticipated. This podcast will review common reasons that individuals seek prenuptial agreements, but it is no way comprehensive. One of the most common reasons for a prenuptial agreement is to protect pre-existing or non-marital property. Under the Divorce Code, assets owned prior to marriage, which are kept in separate names, remain the assets of the individual owner. However, any increase in value of those assets or marital property to be distributed by the court. The most common provision in prenuptial agreements provides that this pre-existing property will continue to be owned by the individual bringing the property into the marriage. The agreement protects the asset's growth, transfer, and income, as well as additional assets which may be purchased or obtained with those separate assets. Another common reason for a prenuptial agreement is the protection of inheritances or gifts received during the marriage. Oftentimes, it is not the party getting married that is seeking the protection, but it is that person's parents who seek protection of the assets accumulated over a lifetime of savings and investing. So if one party stands to inherit significant funds after a death of a family member, a prenuptial agreement can assure that those assets, kept in separate names, will remain the property of the family member and will not later become subject to claims by a spouse. Prenuptial agreements can also serve as part of a business succession plan. Many families plan to pass on a business or an interest in a business to their children and grandchildren. They do not want to have the business embroiled in a divorce or have a spouse make any claim on the business at all. A prenuptial agreement may be used to protect any portion of the business transferred to the child, even if at the time of signing the agreement, that transfer has not been set in stone. Under the Divorce Code, marital property includes the majority of assets acquired during the marriage, no matter the title of the property. Most prenuptial agreements define what will be considered separate property, not distributed between spouses, versus what will be considered marital property, which will be distributed between the spouses. The easiest manner in which to define marital property is to limit it to those items which are actually placed into jointly held names during the course of the marriage. Many people signing a prenuptial agreement will elect to exclude from marital property anything that is maintained in separate names. This offers the maximum amount of asset protection. Prenuptial agreements will generally provide for the division of marital assets, most often being divided 50-50. One issue that is a concern for many individuals executing a prenuptial agreement is the payment of spousal support, alimony, pendente, lite, or alimony. These are all forms of maintenance payments made to a dependent spouse. This obligation arises automatically from marriage and may be calculated pursuant to guidelines provided by statute. Many prenuptial agreements call for a blanket waiver of these obligations of payment. In the event the payment is provided for in the prenuptial agreement, it is carefully structured and may consider the number of years of marriage as well as the amount and duration of the payments. In the event of death, many individuals reserve the right to protect all separate property from inheritance claims by the other person. In addition, it is common to see a blanket waiver of inheritance rights, instead providing that a party may prepare estate planning documents as they see fit. In the alternative, certain security may be provided for the surviving spouse as long as separation has not occurred. These terms may provide for a lump sum payment, the provision of a life insurance policy, or the designation as a beneficiary on a retirement plan. Marriages are not unlike many other forms of partnerships. A carefully drafted prenuptial agreement will address how property, debt, and support would be handled in the event the partnership dissolves as a result of divorce or death. For many, this is much more preferable than having the courts make such decisions. If you wish to discuss a prenuptial agreement in more detail, please see the information on the following slide.